Hello friends, in the series on the income tax cases, today we will discuss a very important issue regarding the timeliness for issuing the notice under section 148 along with order under section 148A clause D. This issue has been taken by Honorable Delhi High Court in the case of Raminder Singh versus Assistant Commissioner of Income Tax, and this case has been reported in 461 ITR at page number 368, and the date of the judgment is 5th September 2023. This case relates to the assessment year 1920. First of all, we will discuss all the provisions in a very short manner to understand the crux of the case. Section 148 says that the notice under section 148 should be served to the assessee before completing the assessment under section 147 along with order passed under section 148A clause D. Now section 148A clause D says that the order under section 148A clause D should be passed within 1 month from the end of the month in which the assessee has to give reply to the show cause notice under section 148A clause B or the extended time given to the assessee for submitting its reply to the show cause notice under section 148A clause B. Now, 5th Proviso to section 149 subsection 1 says that the time which has been given to the assessee or the extended time which has been given to the assessee for giving its submission or reply in regard to the notice under section 148A clause B should be excluded for passing the order under section 148A clause D. And the 6th Proviso says that if after excluding the time which is given to the assessing officer according to 5th Proviso to section 149 subsection 1, if that time is less than 7 days, then minimum 7 days should be given to the learned assessing officer. From this, it becomes very difficult to grasp these provisions, so we will understand these provisions according to the facts of this case. In the present case, the show cause notice under section 148A clause B was issued to the assessee on 31st March 2023 to give the reply up to 10th April 2023. If we plainly see the reason, the provisions for issuing the notice, then the time limit for issuing the notice expires on 31st March 2023. But the assessee has been given the 10 days time to give the show cause reply. So this 10 day will be extended or will be added to the limitation period which is expiring on 31st March 2023. So now the assessing officer can issue the notice under section 148 on up to 10th April 2023 because the time available to the assessing officer is basically nil time because the assessee has given the reply to the notice under section 148A clause B on 10th April and he has to issue the notice on 10th April. So if this time is colliding, so it means that the assessing officer does not have practically no time to issue the notice under section 148. So according to 6th Proviso to section 149 subsection 1, the assessing officer should be given at least 7 days. So in the present case, the notice under section 148 can be issued up to 17th April 2023, and in the present case the assessing officer has issued the notice under section 148 on 17th April 2023. So according to Delhi High Court, the assessing officer has not crossed the time limit and he has issued the notice on time. Friends, this case is very important because all the provisions, section 148, 148A, 149 along with 5th and 6th Proviso should be read in conjunction. In the present case, it is the contention of the assessee that 5th Proviso should be applied, but Delhi High Court said that both 5th and 6th Proviso should be read in conjunction and at least 7 days time should be given to the assessing officer. If in the present case the notice under section 148 has been issued by the AO after 17th April, so in that case the notice will become time barred. One more issue was also before Delhi High Court in the present case was that the assessee was saying that since the approval under section 151 has not been given to the assessee, so on this ground itself the notice under section 148 should be quashed. So for this the court said that it is unwarranted that to demand on the part of the assessee that the notice should be quashed just because the approval has not been given to the assessee suo motu by the assessing officer. But the rule is that if the assessee asks this approval from the assessing officer, then it is the duty of the assessing officer to give the copy of the approval. So friends, whenever you receive the notice, first of all you should ask the copy of the approval from the assessing officer. If he does not give suo motu, then on that ground you cannot term that my notice under section 148 is invalid. At the end of this video, once again I am repeating the name of the case. The name of the case is Raminder Singh versus Assistant Commissioner of Income Tax, and this case has been reported in 461 ITR at page number 368. The matter has been decided by Delhi High Court and the date of the judgment is 5th September 2023.